Israel is still dealing with the news that broke Sunday night that the United States and Iran have reached a deal. But rather than focusing on that troubling development, I started thinking about deals that might protect Israeli interests, over which Israelis themselves have some control. And I'll suggest one today, relating, of course, to the eternal clash of Israeli law and politics. I'm Aylana Meisel, Executive Director of the Israel Law and Liberty Forum, and this is Basic Law. Now, one of the many stories getting lost in the fog of war is the continuing standoff on judges between the Minister of Justice and the Supreme Court, where both he and members of the court sit on the Judicial Selections Committee. The minister hasn't convened the committee since January 2025, leaving vacancies across a legal system crushed under its caseload in the best of circumstances. In a system of under 900 judges nationally, over 80 positions could be staffed up this year. The backlog in pending cases is in the hundreds of thousands annually. Now, the legal story has been developing here for years, but we'll cut to the chase. 2 weeks ago, the High Court ordered the minister to convene the Judicial Selection Committee as soon as possible, specifically to appoint judges to the district courts, where they say that understaffing is critical. The court said Levin's insistence on full consensus before any appointment directly contradicts the judicial appointments law. In a pointed aside, the court noted that Levin himself had created the time pressure that he was now citing as a reason for offering to pursue stopgap measures rather than permanent judicial appointments. Now, it's specifically on that point that I think that the potential for a breakthrough hinges, because the time pressure that the court is citing certainly exists, but it isn't recent, and the court has had its own role in exacerbating the issue. And I think it has an opportunity to show serious leadership in helping solve it. But to understand how and why, we need to understand what's at stake, the incentives on each side, and how we got here. The Judicial Selection Committee has 9 members. There are 3 Supreme Court justices, one of whom is the president of the court. There are 2 ministers, one of whom is the Minister of Justice. There are 2 Knesset members, one from the coalition and one from the opposition. And in addition, there are 2 representatives of the Israel Bar Association. So what happens under a right-wing government usually is that the coalition's 3 seats face off against what is a block of 6. There are 3 justices, the 2 bar representatives, and the opposition MK. The committee was designed to ensure that legal professionals were selected primarily by legal professionals, both for their expertise and so that the bench was not beholden to political interests. What happens today is that appointing a Supreme Court justice requires a supermajority of 7 of the 9 committee members. So, Levin cannot get anyone onto the court without at least 4 members of the opposing bloc. And because a simple majority of 5 suffices for lower courts, he knows he'll lose on those appointments as well. Now, judges in the district courts are among the most likely successors to the Supreme Court bench, so their appointments matter enormously too. As we know, the choice of who sits on the Supreme Court in Israel today is no less important than who occupies the chair of the prime minister. So Levin's demand is broad consensus. In practice, unanimity before he acts. And his legal position is that the authority to convene the committee belongs to him alone, and that the court has no standing to order him otherwise. The plain text of the statute seems to support this as well, as does a substantial part of Israel's legal community. But the court disagrees. In the run-up to January 2025, it ordered Levin to convene the committee 3 separate times to elect a Supreme Court president after Chief Justice Chayut's retirement. 16 months into that process, in a bizarre or an innovative move, depending on whom you ask, the court ordered the committee convened. And it was at that meeting, in the absence of coalition members, that Justice Yitzchak Amit was chosen as the court president. Now, that may have been penny-wise and pound-foolish for the court's legitimacy, because to this day, the Minister of Justice and many on the right look back on that moment as a hijacking. And because this telenovela does not have enough twists already, as president of the court, Amit sits on the very committee that the court has now ordered Levin to convene to pick its future successors. The Knesset passed a reform to the Judicial Selection Committee earlier this year, which its drafters believe will require compromise no matter who is sitting there. It's supposed to kick in the next Knesset. If Levin can hold out on convening the committee, to his reading, applying pressure on the system while avoiding being forced to rubber stamp selections, the new structure in the next Knesset might yield more favorable outcomes for anyone in the coalition. Then again, the court is hearing challenges to that reform next week, so whether that survives is its own question. Let's move to the court. The court also has limited incentive to offer concessions. Justices don't run for elections, and those on the bench will be there long after this Ministry of Justice has passed hands. And remember, these same justices will soon decide whether the committee can be reformed at all. So they have the time, and whether it's justified or not, they ultimately have the power. The court knows that its own members cannot be replaced under the current circumstances because they also lack 7 of 9 votes. So while this court too is swimming in thousands of pending cases alongside the 10 or 11,000 proceedings it handles annually, it is focused more on getting the committee to convene for judges requiring only that majority vote of 5. Now, it's hard for outsiders to understand just how bogged down the Israeli legal system is. And if that sounds like a technical claim, it really shouldn't. We're talking about people left in prolonged uncertainty over their businesses, over their property, appeals on criminal convictions. We use neutral-sounding language to talk about the decisions that deeply, deeply affect citizens' lives. And so it matters to Israelis that in 2024, for instance, in a country of just 10 million people, the judiciary had something like 475,000 cases still pending. It closed over 930,000 cases that year, and it opened another 911,000. These are slight approximations. Most of these cases go to what we call magistrate courts, which are the lowest court level. 8 to 9%, meaning 8 to 9% each, go to district and labor courts. And the Supreme Court sits atop it all, hearing just under 1% of the system's cases overall. But thousands of cases are pending at every level. By 2024, a civil appeal at the Supreme Court took an average of 23 months. Criminal appeals took 11. The fastest moving cases are constitutional ones, where the petitioners start right at the level of the Supreme Court. In 2019, an organization called the Movement for Governability and Democracy published a study based on 4 months of live courtroom observation, with students timing every case. They found that despite being the minority of petitions the Supreme Court receives, constitutional petitions make up 30% of Supreme Court hearings, and consume 37% of what we call weighted judicial time, because these cases draw larger panels and run longer than other sorts of cases. But when we talk about these issues, the responsibility for the backlog is pointed squarely at the political rung. And this too is something which helps the court avoid compromise. Long term, the key aim for both the court and the minister should be strengthening the legal system's integrity. Legal reform aimed at trimming frivolous litigation and improving predictability of outcome. But on the immediate, now urgent question of staffing the judiciary, I think the court has a much larger role to play than it gives itself credit for, and a chance to display grace and leadership by making the minister an offer he can't refuse, while also showing that it deeply cares about the issue that it is claiming is critical. And that offer would be the restoration of standing for constitutional cases. Here's what that is and why it matters. Standing bears on many of the most important and political cases that the court chooses to hear. This doctrine is one of the oldest features of common law legal systems. Courts exist to resolve disputes between parties with a concrete, personal stake in the outcome. So, for instance, under Article 3 of the U.S. Constitution, federal courts are limited to adjudicating what we call cases or controversies, which is a real dispute between real parties with real stakes. You can't walk into an American federal court simply because you believe that the president has passed an unconstitutional executive order. Israel once had that same limit. In the early years of the state, the High Court adopted what scholars call the Grand Rule of Standing, drawn from English common law. You had to show the government breached a legal obligation toward you personally, causing unique and measurable harm. But in Israel, that changed in 1986 in a case that we've mentioned before on this show, Ressler versus Minister of Defense. Ressler centered on the sweeping military draft exemptions granted to Haredi yeshiva students. For decades, standing rules had kept this issue out of the courtroom, where an individual citizen suffered no unique injury from a defense policy applying to others. In 1986, a reserve officer named Yehuda Ressler and a serial constitutional petitioner brought a fresh challenge on this matter, and Justice Aaron Barak reversed course on standing. His reasoning, quote, "It is not the right that creates the disputes, but rather the dispute that creates the right. Judicial resolution of problems that possess a public nature or even a political nature is not a violation of the principle of separation of powers. My approach is that requiring the existence of a right or interest as a condition for standing lacks any philosophical ground. It has no moral ground, and it violates the rule of law." Like so many of the Barak doctrines, this was revolutionary, and the change to standing also coincided with the abolition of justiciability as a real limit. So from Ressler onward, the court would hear virtually any petition from virtually any petitioner on virtually any question of public importance as it saw it. What does that look like in practice? Let's go to a few examples. In 2016, the court struck down the government's framework agreement with Noble Energy for developing the Leviathan gas field, Israel's largest offshore discovery. This was on petition from parties with no direct economic stake. It was a tremendously important economic and geostrategic deal. The contract was eventually renegotiated with a year's delay, and the costs of that delay have never been fully tallied. A famous 2018 case challenged the military's rules of engagement. It was dismissed, but in part because once the suit was brought, the Army quickly modified its rules to avoid a potentially unfavorable ruling. That suit was brought by an array of radically activist groups against the Army and would not have survived the traditional standing test. The more restrictive rules of engagement that resulted are something that many on the right believe contributed to the security failures of October 7th. An overly cautious fighting culture that cost extra lives. In March 2024, 5 Israeli human rights NGOs, again associated more to the left, petitioned the court to order full humanitarian access to Gaza, including reversing the electricity cutoff during active wartime. The court heard the case for a year, repeatedly demanding detailed responses from military commanders before rejecting the case on the merits in 2025. Like so many others, this was a question where any comparable democratic judiciary would have declined to hear the case. But even under Israel's expansive justiciability standard, the case should never have been heard on standing grounds alone. Okay, last example. Professor Menachem Mautner has also documented a steady increase in petitions filed by sitting Knesset members with no personal stake in the outcome of the case. To be crass about it, a politician can lose a vote on the Knesset floor and essentially walk across the street to ask the court to strike down the law. Now, because the petitioners who do this are disproportionately from the left, at least they were in his research, and the cases drew heavy media coverage, Mautner, who is himself a highly regarded man of the left, concluded that the public had come to identify the High Court as, quote, an adjunct of the leftist merits political party. So this standing issue is critical. It's one of the levers that the court has over even the most political of questions. It's a serious departure from how courts in sister democracies operate, and it speaks directly to the backlog, given how disproportionately the court spends its time on constitutional questions while other appeals accrue. That backlog is a matter of real concern, but it doesn't make sense factually or historically to lay the entire blame on politicians. The court, which again has its own set of backlogged cases, should recognize that some of that burden is self-imposed. In fact, a 2019 Kohelet Policy Forum study by Aaron Garber examined 78 leading public law decisions between 2014 and 2018, and he found that roughly 58% were brought by petitioners who would have lacked standing under the traditional doctrine. So here's the rub. Were the court to reinstate that doctrine through a major ruling clearly restoring the old standard, I think several things would follow. First, its case to the minister about backlog would carry far greater weight, because the court would be taking steps within its own walls. The volume of petitions to the court would fall substantially, freeing institutional bandwidth for the backlog actually harming ordinary citizens. The relative importance of any justice's ideology would also diminish, since the range of questions that the court could address would narrow. The structural terror around judicial appointments would ease. So the primary reason Levin and the right view every Supreme Court seat as existential is that an activist court with unlimited standing and justiciability can dictate national security, economic, and social policy from the bench. So if you narrow the reach, even partially, the stakes of who sits there fall with it. While not solving all of the systemic backlog, remember the court itself handles under 1% of all the cases in the system, I do think it would ease pressures on the court and also offer Levin and Israeli society a gesture of immense and far-reaching value, a sign of partnership in a clash where the notions of victory and defeat don't and shouldn't really fit. If the court does this voluntarily, as an acknowledgement of its considerable involvement in Israeli political life, and again offering only a partial withdrawal, I think that would be a measure restoring faith among parts of Israeli society that are losing it, while maintaining the institution's crucial independence. Now, it's true that the court earned much of its expanded legitimacy by acting when politics failed or refused to, and the Haredi draft is the clearest and most painful example today. Governments dependent on the Haredi coalition partners wouldn't force the issue for decades, kicking the can down the road and violating their own egalitarian promises because the political cost was too high. So the court stepped in, and it's the prime mover behind the more aggressive approach that much of the public, which is war-torn and weary, now supports. If the court pulls back on standing, that question returns to a political system that has failed before and may fail again. I acknowledge that, but that's a process I believe Israel needs to go through. A system that knows that its judges will always, quote unquote, fix its mistakes has no incentive to do the painful work of compromise, and a court that substitutes its judgment for the legislatures on social policy can't ultimately protect democracy because it's overtaking one of the key democratic functions. Politics is where the hard questions of Israeli democracy need to be contested, and it's the only place where compromise might eventually be achieved. In a major case argued recently before an expanded panel, attorney David Peter compared the court to the Greek hunter Actaeon in mythology. He was transformed into a deer by a vengeful goddess and hunted down by his own hounds. So Peter compared the court to Actaeon and essentially said that rather than the hunter, the court is now the deer. A court that enters a political arena shouldn't be surprised when it's then treated as a political actor. I think the logic has some merit, but in this case, I actually read the situation as an opportunity. The court today is on the political field whether it chooses to be or not, and for that reason, I think it should engage in what I would classify an act of statesmanship. It can choose from genuine institutional strength to begin returning to a more limited self-understanding for the good of its court, for the good of the system, and for the good of the country. Unlike the Iran deal, this one is entirely within our hands. I'll see you next week.